Good afternoon, everyone. My name is Amy Smollers, and I'm Executive Director for the Center of Healthcare Education and Workforce Advancement at the Massachusetts Health and Hospital Association. And I want to welcome you to today's webinar, ADA Title III and Related Accessibility Laws, Insights for Healthcare. A few logistics before we start. We are in listen-only mode today, so if you have questions, please enter them into the chat feature, and we will do our best to get them during our time together. I also want to take a moment to thank MHA's 2026 annual sponsors, as well as our strategic partners for their support in underwriting today's webinar, which is just one of many events we offer throughout the year to connect our members with leading experts to help address timely issues like the one today. I'm pleased to introduce our speakers from Seyfarth Shaw today. Jennifer Serafin is a partner at Seyfarth Shaw. She spent 17 years in, in the U.S. Attorney's Office for the District of Massachusetts, where she built and led the nationally recognized Civil Rights Unit and served as a key member of the Office's senior leadership team. Michael Steinberg is also a partner at Seyfarth Shaw. He brings decades of experience and specializes in employment litigation, and ADA Title III and public access. Thank you both so much for being here today, and I'll hand it over to you to get us started.
Excellent. Thank you so much, Amy, and thanks to MHA for putting on this terrific series. As you can see from the slide here, we are going to be talking today about accessibility, specifically entities' obligations under Title III of the ADA and related laws that apply to healthcare facilities and organizations. And I'm thrilled to be joined by my partner, Jennifer Serafin, in that endeavor. So if we want to turn to the next slide, I'll quickly cover the ground rules here. You can see the legal disclaimer. I will not insult your intelligence by reading it to you. If we want to go to the next slide, those are our photos. And so for the agenda, we're going to begin. Jennifer is going to start us off with an overview of the applicable laws here. That's Title III of the ADA, the Rehabilitation Act, and Section 1557 of the Affordable Care Act. We'll then launch into some specific areas of accessibility. We'll touch on physical and programmatic accessibility because although we're going to be focusing on digital and website content here today, we don't want folks to forget that these obligations extend to all aspects of accessibility. We will then focus our attention on web content, mobile apps, electronic medical records, and so forth, telehealth appointments. Third, we will zoom in on one key obligation that affects website and mobile apps and digital content, which is the provision of auxiliary aids and services. And lastly, we will talk about service animals and the ongoing challenges in handling those requests. So if we want to turn to the next slide, I will now hand it over to Jennifer.
Terrific. Thanks so much, Michael. I'm happy to be here and to dig into this with all of you. So let's just get started and go to the next slide. Most of you probably know this background info on the ADA. The statute recently celebrated its 35th anniversary. And there are different provisions to the ADA, as Michael referenced. Title I covers employment. Title II is state and local government, as well as public transportation. Title III is public accommodations, and Title IV is telecommunications. So what we're here to talk about today is Title III. But we just wanted to sort of run through that so that you can also be mindful throughout the presentation that you're also going to have obligations under Title I as well, in terms of making sure that you are your facility, all of your equipment, et cetera, content is accessible for your employees as well. But for today's purposes, we're going to focus on public accommodations, which is Title III. So let's check out the next slide. Just some more sort of background on the ADA. Again, most of you probably know this if you have, any familiarity with the ADA. You're required under the statute, which is a highly technical statute, to have facilities that are accessible to people with disabilities. So if your hospital, your clinic, is open to the public, sees patients, obviously you need to be in compliance with the ADA. But that also gives rise to a lot of things that folks don't often think about. They think about the ADA and they think about physical accessibility, but there are other components to it as well, which is the requirement to make reasonable modifications. And that involves not only the physical setting, but also policies, practices, procedures. Really soup to nuts, every single thing that your organization does. I think, you need to be thinking about in or with an accessible or an accessibility lens. And that also includes effective communication with the individuals who come into the facility, or again, who work there. That's the Title I piece, which is sort of beyond the scope of what we're going to talk about today. But you should also be thinking about that as well. And so it's folks who come in, whether it's patients, whether it's, their caregivers, every single part of what you do is something that is in many ways governed by the ADA. And we're going to talk, as Michael said, about auxiliary aids and services as well, because that's something that often trips people up. So that's sort of the statute broadly. I'll just touch on remedies quickly because it's important to think about, the end game or the possible exposure as you're thinking about how to comply with this highly technical statute. So, under the ADA, for the most part, individuals cannot get damages in the way that we might think of them in, a big lawsuit, like compensatory damages, punitive damages. It really is focused on injunctive relief and covering attorney's fees and costs. But it doesn't mean that there is no possibility for any amount of damages. There is the ability to sort of tack on state laws, and some of those state laws do, depending on which state you're in, do have provisions for damages. Now, if the Department of Justice is involved in an ADA action, that's where an individual can collect money damages. And there are also pretty hefty penalties. As you can see here on the slide, it's over $100,000 for a first violation and over $200,000 for a subsequent violation. Now, that seems pretty straightforward, but what counts as a first violation versus a subsequent violation is something that can trip people up. So, for example, if on a Tuesday, you have 6 different people who, over the course of that day, come in and need an ASL interpreter, and the ASL interpreter has an emergency that day or has called out sick, that potentially is 1 violation followed by 5 subsequent violations if each of those 6 people were not able to effectively communicate with, their doctor, their caregiver, whomever. So that's just something to think about in terms of the ways that those damages can sort of add up quickly. And before we go to the next slide, I just want to mention, as we think about the ADA generally, to just sort of highlight for folks that if you go to our website, seyfarth.com, we have an ADA blog that focuses on Title III. There's a lot of content on there that is very bite-sized and I think pretty easily digestible. We're not posting these sort of really long articles. So if you're looking for just practical advice and practical updates, I encourage you all to check that out. Why don't we go to the next slide? And Michael, do you want to talk about the covered entities?
Sure. So we're Jennifer gave you kind of an overview of the ADA and zoomed in on Title III. But stepping back again for a minute, who's covered under Title III? It's going to be, as you can see, certainly a hospital, right? It's going to be a provider's office. Those professional offices of healthcare providers and hospitals. They're enumerated in the statute. But there are other areas that are regulated, right? There are other places and services that are regulated. For example, transportation is something that you can see is regulated under the ADA. And in the healthcare sector, that can come into play when, for example, transportation is being provided for folks who need specially equipped vehicles to get to and from a facility. So you'll see that there's almost no question that Title III is going to be regulating the healthcare organizations that you work with. But beyond Title III, we mentioned at the outset that there are other laws that come into play that regulate healthcare providers. And before I get there, I want to quickly note that there's a green box in the upper right-hand corner of this slide. You might be wondering, why does it say, must it be a physical place? I'm going to talk more about this in a few minutes, but I wanted to plant the seed here. There is an ongoing split among the courts, the federal courts in particular, over the question of whether Title III extends to the accessibility of websites, both in a vacuum or even as connected to a physical place. There are some courts that have taken the view that the digital world, a digital place like a website, is not itself covered under Title III unless there's a connection to a physical place and the lack of accessibility of the website has impacted a person's ability to access a physical place. There are other courts that say no, websites are covered, right? There's no requirement that the public accommodation be a physical location. So we'll talk more about that, but I just wanted to plant the seed because that is a debate under the Title III of the ADA that relates to its very specific language, right? Talking about a place of public accommodation. But if we turn to the next slide, as you are probably familiar, there's another really important federal disability rights statute, which is the Rehabilitation Act. And like under the ADA, the Rehabilitation Act has provisions that focus on employment, for example, Section 501, which regulates federal agencies when they are employers. And then it has really what was the prequel to Title III of the ADA, which is Section 504, that prohibits discrimination on the basis of disability in the programs or activities conducted by federal agencies or programs or activities of entities that receive federal financial assistance. Section 504 defines, for purposes of that, federal grantee provision, entities that are primarily engaged in the business of providing healthcare as covered entities. So once again, Section 504, in tandem with Title III of the ADA, is a statute that you have to comply with. Luckily, the obligations of hospitals and providers, places that are regulated by both statutes, are going to be consistent with each other, and they really complement each other. But unlike the ADA, which for Title III at least, in private lawsuits only allows for injunctive relief, as Jennifer was saying. DOJ can recover civil monetary penalties, but private litigants cannot recover money damages under Title III. Healthcare entities do have monetary exposure under federal law, even in private lawsuits, because money damages are recoverable under Section 504. The silver lining is they're really limited to essentially contractual and quasi-contractual types of damages. So there's still no punitive damages and emotional distress damages. And to recover money damages under the Rehabilitation Act, there is a showing of intentional discrimination that's required. Now, we're mostly focused on Massachusetts. So here, as Jennifer again alluded to, we pause to point out that all sorts of, a buffet of different monetary remedies is available under the state public accommodations law, which is chapter 272, section 98. So really, this is an area of compliance that presents not only enforcement risks in terms of government enforcement, but private money damages suits as well. And if we turn to the next slide, we'll add one more piece to this puzzle. Healthcare entities are also regulated, again, as many of you probably are familiar, by Section 1557 of the Affordable Care Act, which expressly incorporated the Rehabilitation Act's prohibition on disability discrimination and applied it to health programs and activities that receive federal financial assistance. So again, networks and facilities that receive Medicare and Medicaid funding, that's going to be virtually all healthcare organizations, right? They are going to be subject to these obligations, whether we're talking about issuers of insurance, hospitals, clinics, ambulatory surgical centers, physician practices, nursing homes, you name it. And even for entities that are not principally engaged in the provision of healthcare, such as, for example, one can think of a retailer that is primarily not providing healthcare. That retailer may have within it, say, a pharmacy or some sort of a clinic that is receiving federal funds. That may be, at least to that extent, right, the healthcare program or activity within that retailer may be covered. So the ACA really takes the Rehabilitation Act coverage, takes the ADA Title III coverage, and expands it even more broadly, as we know, to the insurance market regulations under the ACA. The enforcement mechanisms, again, are drawn directly from the Rehabilitation Act. So healthcare employees, in sum, have to comply with a panoply of disability discrimination mandates, Title III, the Rehabilitation Act, and Section 1557. So let's turn to the next slide. Okay, so we are going to be focused, and I know the program was really billed as focusing on digital accessibility, but we did want to, emphasize the point that accessibility extends broadly to really all aspects of the services of a healthcare organization. So we wanted to touch briefly on physical and programmatic accessibility, just to remind folks and maybe highlight a few points that are unique to the healthcare context. So let's turn to the next slide. Okay, so as we just discussed, healthcare providers have obligations under the ADA, under Section 504, and the ACA to make their facilities and services available in an accessible manner. And I want to note that you'll see a reference here to Title II of the ADA that may not be applicable to many of you, but note that public entities, such as, for example, a county hospital or a municipal hospital. Massachusetts has some, specialized care centers that are, regulated by and operated by the Commonwealth of Massachusetts. Those sorts of entities are also subject to the obligations of Title II of the ADA, which relates to the programs and activities of state and local governments. Again, all of these non-discrimination mandates are going to be really working in tandem. They're imposing similar, if not identical, requirements when it comes to physical and digital accessibility. But at the outset, what the Rehabilitation Act and the ADA were really focused on were physical accessibility and access to the goods and services of places of public accommodation. And as Jennifer said, those requirements, particularly related to architectural and physical accessibility, are very technical. There's a set of standards for accessible design. The most recent version are the 2010 standards. The Access Board is always engaged in an ongoing process of, reevaluating its standards and criteria for accessible design. And even for facilities that were in existence prior to the enactment of the ADA, there is also an obligation under Title III for readily achievable barrier removal. Okay, so those are architectural, physical barriers to accessibility that can be remedied without the entity having to undertake a significant burden or expense to do so, right? If it's technically feasible to do so, and would not impose essentially an undue administrative or financial burden, then there is also an obligation to engage in barrier removal affirmatively. All right, let's turn to the next slide.
Okay, great.
Sure.
Yeah, so you all probably know a lot of this in terms of the types of sort of physical, durable medical equipment that needs to be accessible. So I'm not going to read everything on here, but I am going to give you some handy dandy tips or places that I think are potential weak spots that you may want to review wherever you work, just based on my nearly 20 years with the DOJ. So, for example, let's focus on staff training, which is at the very bottom here. I think a lot of organizations excel at training the sort of meaty middle part of their workforce when it comes to accessibility. But what they may forget about are the folks that are sort of on either side of that. So, for example, doctors, doctors are busy. Are they doing the same amount of training? Perhaps not. And so one thing to think about when we think about the ADA is things like transplants, for example. And this is a matter that I handled when I was at the U.S. Attorney's Office. There was a doctor who didn't want to give a kidney transplant to someone who was on medication for opioid use disorder. If that decision is infected by a bias based on a disability, then that is a violation of the ADA. So I highlight that because it's important to make sure that your doctors, your executives, et cetera, are also getting robust ADA training. Also, the people sort of at the other end, think about the maintenance folks, the people that you may not think about when it comes to training that you may not encounter sort of every day. I also had an investigation when I was at the U.S. Attorney's Office where one of the workers, when there was a snowstorm and then a second snowstorm and a third snowstorm, had put all of the snow when they were clearing the parking lot into the ADA accessible spots. And so there was this huge mound of snow there. Now, I'm sure it wasn't ill-intentioned. Probably when they were plowing, that was the area where there were no cars, so that they can just kind of put all the snow there. But the result was that there were essentially no accessible parking spaces available for anyone who was coming in to use the facility. So again, I think that that's the kind of thing that you may not think about when it comes to training. You really do want to make sure that everyone in the organization is getting that robust training. And then if we look at the next slide, I know, here we're supposed to be focused on the sort of physical equipment and physical setup. We just wanted to show you this in case you haven't seen this before or something like this. There are pictures in the DOJ and HHS's joint technical assistance that can sort of give you a visual for how spaces should be set up. I think this is important because, as you all know, many of our buildings, especially in Boston, can be small. Patient rooms seem to be getting smaller and smaller. Everything is shrinking. So you really want to make sure that you are, either really focused on this yourself or engaging with consultants to make sure that, you're getting this right when it comes to the design of rooms, maneuvering things, even if you're changing some patient rooms around, you just want to make sure that you're still in compliance. Let's go to the next slide. So now we're going to transition into websites, apps, and telehealth. So we can go to the next slide. Again, hopefully this is something that you all know and are on top of, but I have found, again, in my experience doing these investigations, people have great intentions and they think they have everything covered, but of course, they don't. And so you have to be thinking about whether patients are getting on the portal or accessing the website or, even reading a lunch menu if you have a cafeteria on site. All of those things need to be accessible. And you might say, yep, we've got this covered. We know that our portal is accessible for people who are blind or low vision. We engaged with a company who ensured us that their app was accessible. But I saw this sort of firsthand, for example, if someone is, blind or low vision, there should be a screen reader, and it should be able to tell them what is, on the screen that they aren't able to see. Well, that is only going to be as good as the information that you put in there. So again, just to give you a very practical example, when I was at the U.S. Attorney's Office, we were trying to make sure we had our own house in order, and there was a picture on the website of the U.S. Attorney. And the description was, if you needed to hear it and have it read to you, the description was picture of the U.S. Attorney standing in her office. And that was it. And what I didn't fully appreciate is that those pictures need to be descriptive. They need to say, or that the language needs to be descriptive of what's in the picture. It shouldn't be just, person standing in their office. It should be, it's a picture of the U.S. Attorney standing in front of her desk in the office. There is an American flag in the background. Think about the other things that are in the picture that could tell you something. For example, if you and I saw, a pride flag in the picture, the American flag, anything else that can sort of give someone a better sense of what is being captured in this picture, that information needs to be described for people who are low vision or blind. And again, it's only as good as what you put in there. So let's go to the next slide. And so now these are some web content accessibility guidelines. Michael, do you want to run through these or do you want me to?
Yeah, sure, I'm happy to. So,
Okay.
you know, before we jump into this, we were wondering, in our own practice, web accessibility has become sort of the new area of focus. It has become a source of a lot of litigation, and people have a lot of, in our experience, compliance questions about web content accessibility. We're wondering, just like a sort of poll of you out there, you can let us know by responding in the chat. How many of you have dealt with inquiries from your internal stakeholders about the accessibility of your organization's website or the electronic medical records program that you use, or the patient portal, or kiosks in your facilities? Any of those sorts of questions. We'd be curious if that's something that you're seeing a lot of, or even a little of, um, from your perspective, because we're certainly getting a ton of questions about this, and it's been for a number of years now the hot new area of litigation. So as we're waiting for those responses to sort of populate, and maybe the answer is you all are already doing this perfectly, and so you don't get any inquiries. But web content accessibility is both very important and it's very hard to get right, because if you think about it, websites are dynamic, right? They're constantly changing. They have many different forms of content. They have videos. They have, as Jennifer was saying, they have graphics. They have payment systems, right? And some of them are the direct result of the programming and design efforts of the organization that operates the website. So we've got one viewer who's saying that with the new Section 504 regulation, which we're going to be talking about in a bit, that they're starting to see questions. It's not a surprise to hear that. Another panelist talking about questions related to the accessibility of a career website. So starting to see as these come in that yes, people are getting these kinds of questions, and that's not a surprise to hear. You are not alone, is the takeaway. So Title III of the ADA in Section 504 now has an explicit regulation. I'm going to talk about the status of that rulemaking in a minute, but Title III and Section 504 require the provision of auxiliary aids and services to ensure effective communication with people with disabilities. And that includes, of course, communication on a website, right? So that obligation to provide auxiliary aids and services really anchors the obligation, the requirement under the law to make web content accessible. The problem is that the ADA was enacted in 1990, right? And the Rehabilitation Act was enacted in 1973. And so the statutes themselves didn't have any specific standards or criteria governing web content accessibility. And so a private consortium has promulgated, right? It's called the World Wide Web Consortium, a set of guidelines which have come to be the standard, the standard that increasingly, regulators have adopted in rulemaking for determining compliance from a web content accessibility perspective. They're called the Web Content Accessibility Guidelines. The W3C is periodically issuing updated guidelines that add success criteria, but at a high level, what the WCAG, or the Web Content Accessibility Guidelines, do is they provide concrete criteria for the accessibility of websites writ large, right? For folks who have visual disabilities, people who are deaf or hard of hearing, people who may have intellectual disabilities, right? There are all different ways in which websites need to be accessible. And so the WCAG is really focused on different user journeys, right? And how those need to be made accessible for people with all different kinds of disabilities. Many of them do focus on people with low vision, and that is because websites are sort of inherently visual. Most aspects of websites are taken in visually. So although the Web Content Accessibility Guidelines are not themselves in the statutes, right? They're not provided for in the statutes. In litigation under Title III and in rulemaking, which you'll see on the slide, I'll touch on this in a moment. The regs and courts in private lawsuits have come to require WCAG compliance in this area. So there are three different areas of rulemaking that have been active and have sort of undergone recent developments. I want to start with Title III. You might think that DOJ would want to tell businesses what the standard for web content accessibility is under Title III. There was an effort to issue Title III guidance, Title III rules related to web content accessibility. Those efforts have been ongoing for years, really, I think going back to the early 2010s. And ultimately, they didn't result in any final rule. And instead, during the Biden administration, what we saw was guidance in which DOJ told us that websites have to be accessible, but not providing a ton of detail as to what the standard is. But there are two other statutory areas where rulemaking has taken place, right? And you'll see that these last two bullet points. The first is actually Section 1557, right? The ACA requires the accessibility of electronic and IT of covered entities. It does not specifically adopt WCAG, but under Section 504, right, the federal government did actually issue a final rule. This was back in 2024 under Section 504, requiring compliance with WCAG 2.1 AA. And the compliance date, you'll notice, was supposed to be last week. But if you'll notice in parentheses, there has been a recent development, which is that the current administration has essentially reset the clock for compliance and has extended the deadline for compliance with the Section 504 rule by 1 year. So that is something that gives you some breathing room here, some additional time to work on the web content accessibility issues that your organization may be trying to address, but it is not by any means an abandonment of the rule. The rule remains in place. The compliance deadline has just been pushed out by a year. Let's take a look at the next slide. Okay. So on the rulemaking front, there are also Title II regulations that similarly require WCAG conformance. Those, like the Section 504 rule, have been pushed out by a year. So I just wanted to mention that. What the current administration has implicitly acknowledged was that these were lofty goals that, covered entities were not, for fiscal reasons, for technical reasons, the complexity of compliance with WCAG, that the deadlines of April and May of 2026 just were not achievable, were deadlines that ought to be extended. Okay, so you'll see on this slide here that we're talking about mobile apps and patient portals. Increasingly, digital, electronic, means of communication are the way in which people are accessing healthcare services. And that means that focusing on accessibility when it comes to a patient portal, when it comes to a mobile app where a patient can log in and access their health information, their test results, their prescriptions, communicate with their providers. These all need to be WCAG compliant. And failure to do so creates a compliance risk, right? It creates a significant litigation risk because mobile app accessibility and website accessibility, those claims, we say in our Title III blog that Jennifer was talking about earlier, that last year those accounted for well over a third of all ADA Title III litigation in the United States that we are aware of, okay? Now, one important point here is the accessibility of a website, that is a non-delegable duty, meaning the owner or operator of the website or of the mobile app has an obligation to make it accessible. And that's true even if the content has been provided by a third party. This would include a payment system. It might include forms that are provided online. It could be, a blog post and the content of that blog post. There are many examples of third-party content on websites, and it's important to remember that the fact that the content has been developed by a third party doesn't excuse the public accommodations obligation to make it accessible. And so that is where, from a practical perspective, having these conversations with your vendors, with the folks who you may be engaging for website design, the companies, the third parties that operate a payment system on a website, as an example, having the conversations about what they're doing to make those systems, to make that content accessible is so important, because simply pointing the finger at a third party is not going to be a very good defense in this sort of litigation. Okay, let's turn to the next slide. So what must be compliant? Quite broadly, under the Section 504 rules, under Title III of the ADA, really all digital content, websites. Think about your scheduling systems. Think about, again, your payment systems, other systems that are accessed by patients and by visitors on a website or a portal. Electronic health records. This is of critical importance. Increasingly, this is how patients access their test results. It's how they access, imaging, right? All sorts of records, summaries of patient visits, you name it. Those items have to be accessible. Electronic communications, a messenger system, email, and so forth. And the accessibility obligation attaches not just to the website, but the mobile app. And it's important to remember that those two are not going to be the same, right? And there may be a perfect website, and you could still have issues with the mobile app. Next slide, please. Okay. I touched on most of this history, so I won't belabor it, but I just wanted to note that, one question that we are getting sort of as we've transitioned from the previous administration to the new administration is, are they still going to be regulating web content accessibility under the ADA? And the answer is basically yes, right? As I said before, the Trump administration has delayed the deadlines for compliance under the new Title II Web Content Accessibility Regulation and the new Section 504 rule, but they have not repealed those rules. They have not indicated that they're going to be engaging in any sort of a wholesale, they have not indicated that they're going to engage in some new regulatory process that will relieve covered entities of their obligations under these rules. So we've got more time to comply. We now have until May of 2027 to comply under the new Section 504 rule, but we still must comply at this point. There's no indication that the administration isn't still interested in regulating here. And in fact, there's one case that we followed, which was not in the healthcare context, but there was a class action settlement, a proposed class action settlement of an ADA Title III website case out in California. The settlement amount was very large, and the current DOJ actually filed the statement of interest and got involved in the case because DOJ was taking the position that the settlement website was actually itself not accessible, kind of ironically. So DOJ is still pursuing enforcement and regulation in the web content area. Next slide, please. Okay, so I'm gonna talk about this at a very high level. I mentioned before that there are some key differences among the different geographic circuits in the federal courts over whether website-only businesses or websites sort of absent a connection to a physical place are regulated. And we just want you to be aware that this is not a settled issue. For purposes of the Massachusetts based healthcare organizations, as I'm going to show you on the next slide, you should assume that websites are covered, even if there is no connection, no evident connection to a physical place. But this is an ongoing area of litigation. Another ongoing area of litigation has to do with testers, right? So let's say somebody from Iowa, a person who's blind or has a visual impairment, is interested in testing the compliance of healthcare provider websites generally with the WCAG. And so goes onto the website of a Boston area hospital or a physician group, ambulatory surgical center, whatever it may be, and finds that the website is non-compliant. But the person has absolutely no intention of obtaining medical care in Massachusetts or at that particular facility. Do they have standing in federal court to litigate the web accessibility case? In the First Circuit right now, the best answer is probably they do, right? So this is an area that causes frustration because you may get a website case from somebody who will never be a patient, will never be a visitor in one of your facilities, and yet the website case may still be litigated by that person. One other point to note is very few web accessibility cases have ever actually been litigated to judgment. That's because they typically settle, and the parties agree on remedial efforts that will be made to improve the accessibility of a website. All right, let's turn to the next slide. And I think we can move on from this. This is just, again, more case law around the question of, are websites covered? And so you'll see on these slides that's played out in the Ninth Circuit. It's played out in the 11th Circuit. The courts have gone different ways on this. Next slide, please. As I said before, here in the First Circuit, the court in a 1994 case said that an insurance, the content of an insurance policy was regulated, even though there were no allegations about the accessibility of a physical place. So here in Massachusetts, we should assume that websites, a hospital website, a physician group's website, even absent any allegations connected to the physical place, is covered under the ADA. Next slide, please. All right, so Jennifer, comes to Seyfarth with almost 20 years of experience enforcing the ADA. Jennifer, do you want to tell us some of your thoughts on, good ways to avoid or defend, if necessary, these website cases?
Sure. Yeah, I'll do this quickly because I know we want to get to auxiliary aids and services and also service animals if we can. Here, what I would just highlight is something that Michael already touched on, which is the third-party content. So for example, if your organization is posting a video on how to properly administer CPR, and you're pulling that content from somewhere else, and you think this is just an educational video that we're going to post, you have to make sure that that content is also accessible. So that means that, if there are graphics, again, that those graphics are explained in Word, in like oral form so that people can understand it, that it's read through a screen reader. You want to make sure that there is text describing what's in the picture. So just be cautious of that, because I think that's an area where a lot of people do make some missteps. The other thing is obviously vendor contracts too. You need to make sure that you're considering accessibility in that context. And then things like, phone lines or anything else that you're going to do to help support accessibility. You want to just not do it, but make sure you understand exactly how it works. So try it out yourself, or get someone to try it out and try to understand their experience so that you can troubleshoot as necessary. So let's go to the next slide. and just focus briefly on telehealth. Here, just wanted to point out that a couple of years ago, HHS and DOJ issued joint guidance on telehealth, which I think is being increasingly used more frequently. So let's look at the next slide. That guidance obviously is something that you can go and seek out and refer to if you haven't already looked at it. I think what's important to note here is that telehealth includes the video conferencing that we might sort of think about, but also the just written interaction, the electronic exchanges about a patient's care. So when you enter a question into the portal and get a response back, you want to make sure that everything there it meets the accessibility standards. Next slide, please. And then, again, traps, the screen reader. I mean, I can't say that enough, how often that gets people into some trouble because they're not checking it. They're not checking what their descriptions are. Also, for example, telehealth appointments. You might say, okay, it seems intuitive that, if someone needs more time because of some sort of impairment, to understand what's being communicated to them, they may need more than a 30-minute appointment. Well, that does you no good if you don't know that ahead of time. So, for example, if the PA is on a telehealth appointment with someone, it becomes clear that they need more time, but that person has an appointment, right after that. That's where sort of things can get, messed up. And so you need to get ahead of these things and ask these questions in the first instance so that then you can plan for a longer appointment, for example, if necessary. Or also offering the telehealth appointment if someone has a physical impairment or is unable to come into the office, or it would be difficult for them to do that. You want to make sure that you're able to offer telehealth if that's something that you are equipped to do and that you offer to other patients. Next slide, please. Okay, auxiliary aids and services. Let's go to the next slide.
All right. You want me to chat about this quickly?
Sure, and then hopefully we can get to service animals in our last few minutes here, because that's usually a
Yes.
hot topic.
Everyone loves to know about service animals and usually has questions about it. So, we were talking earlier about how website accessibility comes from this obligation to provide auxiliary aids and services, unless doing so would result in an undue burden, which is a significant difficulty or expense, or fundamental alteration of the services being provided. Okay, next slide. So as a practical matter, we've talked about some of these today, right? But what are some examples of auxiliary aids and services? Well, for people who are deaf or hard of hearing, they could be, ASL interpreters, right? They could be note takers or exchange of written materials, these sorts of alternatives for folks. And, there was a question in the chat about, do you have to provide a patient's preferred auxiliary aid or service, or does the public accommodation have the ability to determine how it's going to provide the reasonable accommodation? And the answer is the obligation is only to provide an auxiliary aid and service that will facilitate effective communication. And so if that can be done in multiple ways, then the covered place of public accommodation does have a choice, but it is important to take into account and have a dialogue with your patients, with your visitors, about what their preference of accommodation would be. That is something that should be taken into account, and there may be reasons why a particular form of accommodation is less effective for an individual than another. To take the example of a Zoom meeting, right? If there are concerns about using Zoom's closed captioning feature, but there are other alternatives available, like CART, which is basically a real-time program that allows for transcription of spoken language for folks who are deaf or hard of hearing. if that can provide a comparable experience for the patient as the Zoom closed captioning, then maybe that would be sufficient. But it is going to depend on the smoothness of integrating CART into the Zoom platform. It is going to depend on how easy is it compared to the experience that a non-disabled person would have in accessing the Zoom platform. So all of these are going to be individualized inquiries, but the goal is to facilitate effective communication for people with visual disabilities. You know, these could be braille materials and so forth. Next slide, please. All right, so here are some more examples. You know, these materials will be available after the webinar, so feel free to really take a look at just the number of different ways that folks with disabilities may be provided auxiliary aids and services that they need. Let's turn to the next slide. So as I was saying earlier, one critical piece is to consider an individual's preferred method of communication. But don't forget that that might include the family members or companions of people who are coming to seek your healthcare services. So all of this discussion applies not just directly to your patients or customers, right? It also extends to the visitors, the companions, the personal care attendants, right? Who may be accompanying people in your facilities. And please note that you cannot ask somebody to pay for the cost of an auxiliary aid or service, whether that's an ASL interpreter or otherwise. Next slide, please. Okay, now we get to service animals. We will touch on this at a very high level, but if you turn to the next slide, we wanted to make at least some overarching points here about service animals. So Jennifer, do you want to talk to folks just about what service animals actually are?
Yeah. Sure. Just very briefly, service animals under the ADA are going to be a dog or a miniature horse. And that is distinct from an emotional support animal. That's where you're going to see other, you know, a bird, a hamster, whatever else it is. But those are not covered under the ADA. So it's important to make that distinction. Next slide, please. It's also important. Let's go to you can see, and you can obviously read these later. These are just some questions that are, you know, what's off limits, what's totally in bounds in terms of whether it qualifies as a service animal under the ADA, and also what you can ask. So let's look at the next slide. Yes, just an example of, again, that distinction between an emotional support or a therapy animal and a service animal under the ADA. Next slide. Okay, so in terms of what you can ask these two questions and these two questions only. Do you need the animal because of a disability? And what work or tasks has the animal been trained to perform? So you want to train everyone in your organization on these two questions. Let's go to the next slide. And what you cannot do is you cannot ask an individual to explain or verify what kind of disability they have. You can't ask them to show you or have the dog show what they are trained to do. Those are just totally out of bounds. And let's go to the next slide. And you can exclude if the service animal is not house trained, but you can not exclude for reasons like allergies or fear of animals. Next slide. And then, of course, just highlighting that there are Massachusetts laws as well. The important thing to note here is that service animals in training are covered under Massachusetts law. And next slide. All right, look at that. We actually got to the end.
So it was really our pleasure to deliver this to you all. The bottom line takeaway is web accessibility and accessibility more broadly is of great concern to healthcare organizations, and the web accessibility issues in particular. Our biggest piece of advice for you would be seek out experienced and seasoned counsel. on these issues. Thanks, everyone.
Great. Thank you so much, Michael and Jennifer, for sharing your time. And as we said, folks will have access to the recording as well as these slides, which is a really true treasure resource for this. So again, we really appreciate your time today and for folks who attended for this webinar. And again, we hope you have a great afternoon and look forward to seeing you at future MHA events.
Thanks, everyone.